Joining me now is my friend, legal eagle, unofficial counsel, Andrew Weissmann. He's also the former general counsel at the FBI and a former senior member on special counsel Robert Mueller's investigation. So the judge in Fulton County ordered today that no identifying information of jurors and prospective jurors shall be disclosed. That seems fairly obvious given the threats here. But how uncommon or common is that?
In a high-profile case, it is fairly common because it doesn't really need to be triggered by the defendant himself or herself. In other words, in any high-profile case, you're going to be concerned about interference, about press interference, about anybody contacting jurors. Here, though, there's an additional reason for exactly for what you said, which is you're concerned about, remarkably, the former leader of the free world. This is a step that was taken by Judge Kaplan in the E. Jean Carroll the sexual assault and rape case. And so it's fairly common. One thing that I'm still concerned about is that although the judge ordered that this be sort of anonymized and we wouldn't find out the identities, it doesn't mean that the defendant, Donald Trump, and his counsel won't know. And so you're still assuming that Donald Trump will obey the law. And that, as we know from 4 indictments, is a questionable assumption.
What happens if he releases their names? I mean, that's a crazy question to ask, but are there even consequences built into the system?
For anyone else, yes. But, I think there's probably just a natural reluctance here to jail somebody pending trial. But, for Paul Manafort, for instance, when he coached 2 witnesses to lie, he was put in jail by a D.C. judge. It is the norm. Sam Bankman-Fried in the Southern District of New York for financial crimes, so much less serious crimes in terms of the import on democracy, is in jail pending his trial.
So we're also waiting for the Trump team's response to the special counsel's gag order request. It's supposed to come tonight. We'll see. Right. Talk about the stakes of this back and forth, given Trump's behavior, because as a non-lawyer, I'm sitting here watching him make these threats about Chairman Milley and thinking, how is this not a big factor? Is it a big factor?
Yeah, so let's just remember the context we're in. There is a motion before one of 4 judges who have the criminal cases of Donald Trump. There is a motion pending by the government saying, do something, Judge. You've got to restrict in some ways what he is saying about witnesses and jurors and judges and their families. You have to do something. While that motion is pending, as you said, we're waiting for the defense brief tonight. He has done a number of things. He has made these statements about the former chair of the Joint Chiefs of Staff. I mean, it's unfathomable that you're sitting here having that conversation. He has been on air today about possessing a firearm. Well, you and I were on air together when, in the D.C. case, the magistrate judge said, you know what the most important thing is, Mr. Trump, when you are out on bail? Do not commit another crime. Well, it is a crime for somebody who is charged with a felony, just charged with a felony, to receive a gun. And there are pictures on Twitter of him holding the gun.
Does he need a receipt? We don't even know. His campaign came out and said he didn't purchase it, but
that's not, the law is not that you can't buy a gun. The law is 922, to be a nerd. That's why I'm here.
It's a safe place, Andrew. Safe place for nerds.
922N is that you cannot receive a gun that has traveled in interstate commerce. That just means that it's traveled across state lines. A Glock has traveled across state lines because they're either made overseas or they're made in Georgia, but they're not made in South Carolina.
So even not purchasing it, he could have violated.
Exactly. And that happens a lot. There are other parts of the statute that apply to people who are convicted and they can't possess a gun. So the issue here is not that he would be charged with that separate offense. It's that while this motion is pending, what Judge Chutkan will have in front of her is not just the Milley statements, but somebody who has sort of flagrantly boasted about doing something. So to me, he is really daring the court to do something. It's like a child, except it's much more serious because it's somebody who's out on bail on 91 felony counts.
So while we wait for us, because the next step we get Trump's team, their response to the protective order, then Jack Smith's team can respond, and then we're waiting for the judge.
Exactly.
So when we're waiting for the judge, that's the most important part probably here.
Yes.
Is it kind of a yes or no to the protective order? Does she potentially lay out what the consequences are? What are we expecting or waiting for?
So the brief from the government, the reply brief, is due on the 30th of September, and then the judge can rule at any point. The most draconian thing that she could do is she could put him in jail. I do not expect that she will do that, but she could do, for instance, what Amy Berman Jackson did with Roger Stone, which was that she brought him in, she had a hearing, and at the end of which she had all these prohibitions on what he could do in social media and what he could say. There would be nothing wrong with saying to somebody who is out on bail, you know what you can't do? Do not mention witnesses, do not mention judges, jurors, prosecutors, and their families, because I know this sounds ridiculous, but you know what? You can run for president without harassing and threatening witnesses and jurors and judges. Yes, you don't get to live by a different set of rules. I think it's fair to say. Andrew Weissmann, it is always a pleasure. Thank you so much for joining me here on set in Washington. I really appreciate it.